Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this video, we'll explore 3 scenarios involving overriding interests, a key topic in land law under FLK2. Let's dive in. An elderly and vulnerable homeowner entered into a sale and leaseback agreement with his cousin. He agreed to sell his registered home for £65,000, which the cousin told him was the market value. In fact, the property was worth £170,000. The agreement allowed the former homeowner to stay in the house and pay £80 per month in rent. The cousin bought the house with mortgage which is duly registered, but later defaulted on the loan. When the lender made pre-purchase inquiries, the former homeowner erroneously stated that no one was living in the property, even though he still lived there. The lender now seeks to repossess and sell the property. What is your advice to the former homeowner? A. He has been defrauded and has an equitable right to set aside an unconscionable bargain. His equitable right is an overriding interest capable of binding the lender. B. He has an equitable right to set aside an unconscionable bargain, but such right would be overreached. He can instead rely on an overriding interest by virtue of his actual occupation. C. The sale would not amount to an unconscionable bargain as the former homeowner should have made inquiries into the value of his home. However, he can rely on an overriding interest by virtue of his actual occupation. D. He has an equitable right to set aside an unconscionable bargain and this right would not be overreached. He could therefore remain in the property without relying on his actual occupation. E. Even though he has an equitable right to set aside an unconscionable bargain, this would be overreached. He cannot rely on an overriding interest by virtue of his actual occupation. The best answer is D. He has an equitable right to set aside an unconscionable bargain and this right would not be overreached. He could therefore remain in the property without relying on his actual occupation. The sale was clearly unconscionable due to undervalue and the homeowner's vulnerability. Overreaching requires payment to at least 2 trustees. Here, there was only one buyer, his cousin, so overreaching cannot happen. Normally, the homeowner might rely on actual occupation to assert an overriding interest. However, he misled the lender by stating no one lived there. This can prevent him from relying on actual occupation. Therefore, his best protection is the equitable right to set aside the fraudulent sale, and this survives because there was no overreaching. Scenario 2. Same story that the former old owner sold the house to his cousin. The cousin defaulted on the mortgage loan and the lender now seeks to repossess and sell the property. What is the position of the lender? A. The lender can repossess and sell the property with vacant possession as they are deemed a bona fide purchaser for value without notice of the former homeowner's equitable rights. B. The lender cannot repossess the property as the former homeowner's equitable right to set aside the unconscionable bargain takes priority over the mortgage, and the lender had constructive notice of the former homeowner's occupation. C. The lender can repossess the property but must sell it subject to the former homeowner's tenancy rights under the leaseback agreement, as these constitute legal rights that bind the lender. D. The lender cannot repossess the property as the former homeowner has an overriding interest by virtue of his actual occupation, which binds the lender despite the mortgage registration. E. The lender's position depends on whether they can establish they are a bona fide purchaser for value without notice. Given the former homeowner's false statement, the lender likely takes free of the equitable rights and can repossess with vacant possession. The best answer is E. The lender's position depends on whether they can establish they are a bona fide purchaser for value without notice. Given the former homeowner's false statement, the lender likely takes free of the equitable rights and can repossess with vacant possession. The lender's position turns on whether they qualify as a bona fide purchaser for value without notice of the former homeowner's equitable rights. The lender made inquiries and was told no one lived there. The lender has no actual notice of actual occupation. We are not told whether the lender has constructive notice or imputed notice. Former homeowner's false statement is crucial because it prevented the lender from discovering the true position. The former homeowner cannot benefit from rights he actively concealed. Equitable rights versus legal mortgage. While the former homeowner has an equitable right to set aside the unconscionable bargain, this is defeated by the bona fide purchaser defense if the lender indeed had no notice. Scenario 3. An old homeowner sold his home to his cousin at the full market price under a sale and leaseback agreement. The agreement allowed the homeowner to remain in the property at market rent for a fixed term of 10 years. The cousin financed the purchase with a mortgage, and during the lender's pre-purchase inquiries, the lender was expressly informed and aware that the homeowner continued to live in the property. The leaseback agreement was not registered at the land registry. The cousin later defaulted on the mortgage, and the lender now seeks to repossess and sell the property. What is the legal position of the homeowner and the lender? A. The homeowner has no rights against the lender because the leaseback agreement was not registered, and any interest has been overreached by the mortgage advance. B. The homeowner cannot rely on actual occupation to bind the lender because he is not the registered proprietor and did not register the lease. C. The leaseback agreement is a legal lease and, coupled with actual occupation, amounts to an overriding interest that binds the lender. D. The homeowner has no overriding interest because the sale was at full market value and overreaching occurred through payment to the cousin. E. The leaseback agreement is an equitable lease only, but the lender had actual notice of the homeowner's occupation. The lease is protected as an overriding interest. The best answer is E. The leaseback agreement is an equitable lease only, but the lender had actual notice of the homeowner's occupation. The lease is protected as an overriding interest. The leaseback was for 10 years, so it should have been registered under Section 27(2)(b) Land Registration Act 2002 to take effect as a legal lease. But since it was not registered, it is only an equitable lease. Normally, unregistered leases over 7 years do not bind successors, but under Schedule 3, Paragraph 2 of the Land Registration Act 2002, an unregistered interest, like an equitable lease, can still bind a purchaser if the person is in actual occupation and the interest is obvious or known. Here, the lender had actual notice of the homeowner's continued occupation before completion. That satisfies the conditions for the lease to qualify as an overriding interest. Therefore, even though the lease is equitable, it is binding on the lender due to actual occupation and notice. These tables illustrate key principles in land law regarding equitable rights, overriding interests, and protection for third parties. In Scenario 1, an undervalued sale creates an equitable right to set aside the transaction, which can bind third parties unless overreached. However, this right may lose its overriding status if the occupier actively conceals their presence. Scenario 2 focuses on the lender's protection. If the lender had no notice of the equitable right due to being misled, they are treated as a bona fide purchaser and are not bound by the right. Finally, in Scenario 3, a leaseback of over 7 years that was not registered is only an equitable lease, but it can still bind the lender if the occupier is in actual occupation and the lender had actual or constructive notice, making it an overriding interest. Have you noticed how a slight change of fact can affect the legal outcome? That's exactly the skill the SQE tests, and mastering it is key to exam success. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE1. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.